to try civilians under the Uganda People's Defence Forces Act, alleging that the continuance of these trials violates constitutional provisions, including Articles 28(1), 44C, and 210 of the Constitution of the Republic of Uganda. The Constitutional Court, being the court of first instance in constitutional matters, heard the petition and decided that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for the UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. As a result, Sections 2, which now reads as Section 1, Sections 1191H, and Section 179 of the UPDF Act, which expand military jurisdiction of the courts martial to include civilians and classifies civil offenses as service offenses, were declared unconstitutional for violating fair trial guarantees and exceeding the mandate under Article 210B of the Constitution. Finally, the court found that Section 119 is not unconstitutional, provided the person not otherwise subject to military law is tried as an accomplice together with a person who is subject to military law as the principal offender on the same charge sheet. I am abundantly aware of the tension that exists between ensuring unfettered military discipline and compliance. That civilians that aid and abet military persons in the commission of a service offense do by their actions subject themselves to military law under Section 117(1)G of the Act. Section 1171H, on the other hand, subjects to military law any person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces or other classified stores. I find no definition in the Act as would guide a reasonable member of the public as to what type of military equipment is the monopoly of the UPDF, let alone what would amount to classified stores, so as to avoid the prohibited conduct. Article 28(12) of the Constitution considers a criminal offense that is not adequately defined to undermine the right to a fair trial and thus prohibits convictions arising from vague and ambiguous criminal offenses. The need for a precise definition of an offense is associated with a principle of legality that translates into the constitutional principle of void for vagueness. The void for vagueness doctrine essentially requires that a penal statute define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. Thus, legislative provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness. On that premise, therefore, I am unable to endorse the constitutionality of Section 117(1)H of the Constitution. In the result, I find that service offenses as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the legislative mandate of Parliament or the objective of the UPDF under Article 210A of the Constitution. Nor in any case are they inconsistent with Articles 28(1) and 44C of the Constitution. I do additionally find that the provisions of Section 117(1)G of the UPDF Act do constitute exceptional circumstances under which the subjection of civilian offenders to military courts would be justified. To that extent, that statutory provision is not inconsistent with the Constitution. I, however, find Section 117(1)H of the Act to be void for vagueness and therefore inconsistent with Article 28(12) of the Constitution. I would accordingly resolve ground 1 of the appeal in the affirmative, but respectfully find no merit in either ground 4 of the appeal or the cross appeal. I now turn to grounds 2 and 3 of the appeal. The right to a fair trial is anchored in the principle